We haven't drank as much today.
Well, let's do it. I want to be available if you need.
Thank
I
you.
want to come back to order, Port County session.
Okay, let's bring them in. I guess nobody likes the jury charge. Nobody's here for that. Not my favorite activity either.
All rise.
All right, please be seated. Looks like another good lunch day today, right? All right, good. First time I think we've ever had Jack's, isn't it? I believe so.
Thank you. Thank you.
Not much, I mean, I didn't make the decision. All right, I'm about to read the charge, ladies and gentlemen. I estimate it will be about 45 minutes. That's just an estimate. And if there are any typos, I usually correct those as I read. So, and as you know, you'll be able to follow along with me. And, please bear with me. Are we ready? Ready? All right. Members of the jury, the indictment in this case charges the defendant, Roy Donald Coons, Jr., with first-degree murder, felony murder, attempted rape of a child, and especially aggravated burglary. The charge of first-degree murder embraces the lesser-included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The charge of felony murder embraces the lesser-included offenses of second-degree murder, reckless homicide, and criminally negligent homicide. The charge of attempted rape of a child embraces the lesser-included offenses of aggravated sexual battery and child abuse. The offense of special aggravated burglary embraces the lesser-included offenses of aggravated burglary, aggravated criminal trespass of habitation, and criminal trespass. The indictment in this case is a formal written accusation charging the defendant with first-degree murder, felony murder, attempted rape of a child, and especially aggravated burglary. It is not evidence against the defendant and does not create any inference of guilt. To this indictment, the defendant has entered a plea of not guilty. The evidence and arguments in this case have been completed, and it's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions is given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or other, but should consider each one in the light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Excuse me. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Sometimes in the trial of a criminal case, when a defendant is charged with a crime or crimes, the crime or crimes include lesser included offenses. The law permits the jury to find the accused guilty of the lesser included offense, which is included in the crime charged in the indictment, whenever a course of conduct is consistent with the facts found by the jury from the evidence in the case and when the law is given in the instructions of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges under of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. I shall now proceed to explain to you what in law it takes to constitute the offenses as charged in the indictment in this case. Count 1, first-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that he did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree, you will so report, and your verdict in that event shall be: we, the jury, find the defendant guilty of murder in the first degree. If you find the defendant is not guilty of first-degree murder, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense, and next consider the defendant's guilt or innocence of second-degree murder, which is a lesser-included offense of this charge. Second-degree murder. Any person who commits second-degree murder is guilty of the crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond reasonable doubt that the defendant is guilty of second-degree murder as charged in this indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of second-degree murder, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense, and next consider the defendant's guilt or innocence of voluntary manslaughter, which is a lesser-included offense. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed the alleged victim, and that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intent and knowingly, as they apply to this instruction, have been previously explained to you. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of voluntary manslaughter, or if you have a reasonable doubt as to his guilt of this offense, then and in that event, you must acquit him of this offense and next consider the defendant's guilt or innocence of reckless homicide, which is a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when a person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have been previously explained to you. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of reckless homicide, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of criminally negligent homicide, which is a lesser included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. If you find beyond a reasonable doubt that the defendant is criminally negligent, you must also find that the death of the alleged victim was the approximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was not an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of criminally negligent homicide, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense. Counts 2 and 3, I'll be reading these together, although they have several separate elements. Any person who commits felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged attempted rape of a child. That is, that the killing was closely connected to the alleged attempted rape of a child and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the attempted rape of a child. Now, 3A, as to count 3, the killing was committed in the perpetration of the attempt to perpetrate the alleged aggravated burglary. That is, that the killing was closely connected to the alleged aggravated burglary and was not a separate, distinct, and independent event. And 3B, that the defendant intended to commit the alleged aggravated burglary. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all of the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged felony murder. The killing may proceed, coincide with, or follow the underlying felony and still be considered as occurring in the perpetration of the felony murder, and so long as there is a connection in time, place, and continuity of action. If you find from the proof beyond a reasonable doubt that the defendant is guilty of felony murder as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of felony murder, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of second-degree murder, which is a lesser included offense of this count, should be not court count. Now, as to counts 2 and 3, felony murder, the lesser included offenses include second-degree murder. I have previously read the instructions as to second-degree murder, and I will just skip down to the last two sentences. If you find from the proof beyond a reasonable doubt the defendant is guilty of second-degree murder as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of second-degree murder, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of reckless homicide, which is a lesser included offense. And reckless homicide applies to both counts of felony murder, and I have previously read the elements of reckless homicide, and I will go down to the bottom. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of reckless homicide, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of criminally negligent homicide, which is a lesser included offense. Also as to both counts of felony murder. And I have previously read the elements of criminally negligent homicide. I'll skip over to the next page. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide as charged in this count, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of criminally negligent homicide, or if you have a reasonable doubt as to his guilt of this offense, then you must find him not guilty. Count 4, attempted rape of a child. Any person who attempts to commit a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of rape of a child. And 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute attempted rape of a child under the circumstances as the defendant believed them to be at the time, and his actions constituted a substantial step toward the commission of attempted rape of a child. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit attempted rape of a child. The essential elements of rape of a child are as follows. The defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, that the alleged victim was less than 13 years of age. And 3, that the defendant acted either intentionally, knowingly, or recklessly. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of the alleged victims, the defendants, or any other person's body, but emission of semen is not required. Victim means the person alleged to have been subjected to criminal sexual conduct. The definition of intentionally, knowingly, and recklessly have been previously explained. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted rape of a child as charged in this indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of attempted rape of a child, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of aggravated sexual battery, which is a lesser included offense of this charge. Aggravated sexual battery. Any person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. The defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts. That the alleged victim had unlawful sexual contact with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts or the clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2, that the defendant caused bodily injury to the alleged victim. And 3, that the defendant acted either intentionally, knowingly, or recklessly. Sexual contact includes the intentional touching of the alleged victim's, the defendant's, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim, the defendant's, or any other person's intimate parts, if that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. Intimate parts include the primary genital area, groin, inner thigh, a buttock, or breast of a human being. The definitions of victim, knowingly, intentionally, and recklessly have been previously explained. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated sexual battery as charged in this indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of aggravated sexual battery, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of child abuse, which is a lesser included offense of this charge. Child abuse. Any person who commits the offense of child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, other than by accidental means, treated the child under the age of 13 years of age in such a manner as to inflict injury. Child means a person under 18 years of age. The definitions of knowingly and intentionally have been previously explained. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse as charged in an indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of child abuse, or if you have a reasonable doubt as to his guilt of this offense, then and in that event, you must find him not guilty. Count 5, especially aggravated burglary. Any person who commits the offense of especially aggravated burglary is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant entered a habitation or a building other than a habitation. And 2, that the defendant entered with the intent to commit or attempt to commit an assault. The elements of assault are as follows: that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. Those definitions have been previously explained. 3, that the defendant acted without the effective consent of the owner, and 4, that the alleged victim of the burglary suffered serious bodily injury, and 5, that the defendant acted either intentionally, knowingly, or recklessly. Habitation means any structure designed or adapted for the overnight accommodation of persons, including buildings, module units, mobile homes, trailers, and tents. And 2, includes a self-propelled vehicle that is designed or adapted for the overnight accommodation of persons and is actually occupied at the time of initial entry by the defendant. And 3, includes any separately secured or occupied portion of the structure or vehicle, and each structure appertaining to or connected with the structure or vehicle. Occupied means the condition of the lawful physical presence of any person at any time while the defendant is within the habitation or other building. Entered means an intrusion of any part of the body or an intrusion of any object in physical contact with the body or any object controlled by remote control, electronic, or otherwise. Owner means a person other than the defendant who has possession of or any interest other than a mortgage, deed of trust, or security interest in property, even though the possession or interest is unlawful and without whose consent the defendant has no authority to exert control over the property. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act for another. Consent is not effective when induced by deception or coercion, or B, given by a person the defendant knows is not authorized to act as an agent, or C, given by a person who, by reason of youth, known disease or defect or intoxication, is known by the defendant to be unable to make reasonable decisions regarding the subject matter, and or D, given solely to detect the commission of an offense. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment or a function of a bodily member, organ, or mental faculty. Victim means any person lawfully on the premises. The definitions have been previously explained to you. The other definitions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of a special aggravated burglary as charged in the indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of a special aggravated burglary, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of aggravated burglary, which is a lesser included offense. Aggravated burglary. Any person who commits the offense of aggravated burglary is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant entered a habitation or any portion thereof, and 2, that the defendant entered with the intent to commit an assault, and 3, that the defendant acted without the effective consent of the owner, and 4, that the defendant acted either intentionally, knowingly, or recklessly. All of those definitions have been previously explained to you. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated burglary as charged in the indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of aggravated burglary, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of aggravated criminal trespass of a habitation, which is a lesser included offense. Aggravated criminal trespass of a habitation. Any person who commits the offense of aggravated criminal trespass of a habitation is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered or remained on property, and 2, that the defendant knew at the time of such entry or remaining that he did not have the owner's effective consent to do so, and 3, that the defendant intended, knew, or was reckless about whether his presence would cause fear for the safety of another, and 4, that the property entered or remained was a habitation. Owner means a person in lawful possession of property, whether possession is actual or constructive. Enter means any intrusion of the entire body. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act for another. If you find from the proof beyond a reasonable doubt the defendant is guilty of aggravated criminal trespass of a habitation as charged in this indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of aggravated criminal trespass of a habitation, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must acquit him of this offense and next consider the defendant's guilt or innocence of criminal trespass, which is a lesser included offense. Criminal trespass. Any person who commits the offense of criminal trespass is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly entered or remained on property or a portion thereof belonging to someone else. And 2, that the defendant did not have the owner's effective consent to enter or remain. The definitions have been previously explained. If you find from the proof beyond a reasonable doubt the defendant is guilty of criminal trespass as charged in the indictment, you will so report by use of the verdict form that will be provided to you. If you find the defendant is not guilty of criminal trespass, or if you have a reasonable doubt as to his guilt of this offense, then and in that event you must find the defendant not guilty. Okay, just a moment. Expert witness. Actually, wait, hold on just a second. Let me look at this. I should do the deliberation process first before expert witness. So flip that page. Deliberation process. Each count of the indictment is a separate offense and you must deliberate on each count. When you begin your deliberations of the indictment, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the indictment. If you find the defendant not guilty of the indicted offense in that count, or if you have a reasonable doubt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses in that count as set out below and in your verdict form. For example, as to count 1 of the indictment, the defendant is charged with first-degree murder. If you find the defendant guilty of first-degree murder, you may stop your deliberations as to count 1 and report your verdict on the verdict form. If, on the other hand, you find the defendant not guilty of first-degree murder in count 1, or if you have a reasonable doubt as to the defendant's guilt of first-degree murder, you must find him not guilty and then consider the lesser included offense of second-degree murder. If you find the defendant guilty of second-degree murder in count 1, you may stop your deliberations as to count 1 and return your verdict as to count 1. If you find the defendant not guilty or have a reasonable doubt as to the defendant's guilt as to the lesser included offense of second-degree murder in count 1, you must find him not guilty of second-degree murder as included in count 1. Then you will continue your deliberations as to the next lesser included offense as set out below and listed in your verdict form. You must first deliberate on the greater offense as to each count and reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you reach a verdict as to the guilt of the defendant as to a greater offense, you may stop your deliberations as to that count. Now, expert witness. During the trial, you heard the expert testimony of Ms. Jennifer Hornyak, an expert in DNA analysis and DNA evidence interpretation, Detective Chad Gish, a digital forensic analysis expert, Ms. Rachel Mack, a DNA analyst, Agent Charlie Castelbuono, a DNA analyst, Catherine Cross, a forensic biologist, Jessica Davis, a latent print examiner, Detective Chad High, an expert in call detail record analysis, and Dr. Feng Li, a forensic pathologist. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of knowledge, skill, or experience may testify and state his opinions or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. I notice that some of the jurors appear to be taking notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory. And any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show others. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or to say that one is better evidence than the other. You should consider all of the evidence in both direct and circumstantial and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them, if you can, without hastily or rashly concluding that any witness is sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of the witness' reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his contradictory statements as to material matters, if any are shown, and all of the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness' credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. The defendant is not taken to stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. A defendant is not required to prove his innocence. Reasonable doubt is that doubt engendered by an investigation of all of the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every proposition of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant in Davidson County by a preponderance of the evidence, and that it was committed before the finding and return of the indictment. The state must prove beyond a reasonable doubt a defendant's identity as the person who committed the crime. If, after considering all the evidence in the case, you, the jury, are not satisfied beyond a reasonable doubt that the defendant is this person, then you must find the defendant not guilty. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning the verdict. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry or computer, the internet, any internet service or any text or instant messaging service or any internet chat room, blog or website, including but not limited to Facebook, Instagram, Snapchat, MySpace, LinkedIn, YouTube or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until you have reached your verdict and the trial has concluded. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality, as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you find the defendant guilty and name the offense according to your previous instructions. The court will thereafter set the punishment after a separate sentencing hearing. On the other hand, if you find that the state has not proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt, then you must find the defendant not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all possible verdicts in this case. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you will receive reads as follows. Verdict form. We, the jury, find the defendant Roy Donald Coons, Jr., count 1, first-degree murder. Choose 1, guilty of first-degree murder, or not guilty. Second-degree murder. Choose 1, guilty of second-degree murder, or not guilty. Reckless homicide. Choose 1, guilty of reckless homicide, or not guilty. Criminally negligent homicide. Choose 1, guilty of criminally negligent homicide, or not guilty. Count 2, felony murder. Choose 1, guilty of felony murder, or not guilty. Second-degree murder. Choose 1, guilty of second-degree murder, or not guilty. Reckless homicide. Choose 1, guilty of reckless homicide, or not guilty. Criminally negligent homicide. Choose 1, guilty of criminally negligent homicide, or not guilty. Count 3, felony murder. Choose 1, guilty of felony murder, or not guilty. Second-degree murder. Choose 1, guilty of second-degree murder, or not guilty. Reckless homicide. Choose 1, guilty of reckless homicide, or not guilty. Criminally negligent homicide. Choose 1, guilty of criminally negligent homicide, or not guilty. Count 4, attempted rape of a child. Choose 1, guilty of attempted rape of a child, or not guilty. Aggravated sexual battery. Choose 1, guilty of aggravated sexual battery, or not guilty. Child abuse. Choose 1, guilty of child abuse, or not guilty. Count 5, especially aggravated burglary. Choose 1, guilty of especially aggravated burglary, or not guilty. Aggravated burglary. Choose 1, guilty of aggravated burglary, or not guilty. Aggravated criminal trespass of a habitation. Choose 1, guilty of aggravated criminal trespass of a habitation, or not guilty. And criminal trespass. Choose 1, guilty of criminal trespass, or not guilty. Signed by the foreperson and dated. All right. I won't comment. All right. Let's swear the court officer before I read the final instructions.
Do you solemnly swear or affirm that you will take this jury committed to your charge, keep them separate and apart from all citizens, allow no one to speak to them or speak to them yourselves on the subject of the trial, except to ask if they have agreed as their verdict, so help you God? I do.
I do.
All right, ladies and gentlemen, one thing before I read this final section. Okay. Thank you. I'm glad you're working today, Mr. Blake. We have to select one of the alternate who is on the jury. See, without you, I couldn't have it.
6 days he decides to work today.
Okay, that would be juror number 8. All right. All right, I'll see you in a few minutes. I want to speak with you very briefly in a few minutes, okay? All right, now, what I was about to say prematurely is when you go back to deliberate, you can only deliberate as a group of 12. If you take a break, do not deliberate. If you go out for a smoke, do not deliberate. Only as a group of 12, okay? When you retire to the jury room, you will select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them. And I have attempted to read this charge as so to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the indictment in this case is herewith handed to you together with the charge and the exhibits in this case. You may now retire and consider your verdict.
All right. No time for you.
Saw you. Reading your part. All right, folks. I guess you can take a little break for a while, but stay close, okay? And in touch. We'll be in recess.